Good afternoon, and thank you for joining us today. I would like to welcome you to the FortneyScott webinar entitled EEOC Under the Trump Administration, What Employers Need to Know. This webinar will be recorded. All listeners' phones are muted. Today's presenters are FortneyScott's attorneys David Fortney, Leslie Silverman, and Nita Beecher. I will now turn the program over to David Fortney to start the webinar.
Great. Thank you, Sarah. And hi, everyone. Thanks for joining us on what is really an incredibly timely and challenging topic on dealing with EEOC. As Sarah indicated, we have Leslie Silverman joining us. Hi, Leslie.
Hey, David. How are you today?
Wonderful. And you?
Good. I'm happy to join you.
Well, we're delighted to have you. And I think as many, if not all of you know, among Leslie's many accomplishments, it includes that she formerly was an EEOC commissioner and the vice chair of the EEOC. So she is a real insider on the topics we want to unpack today. And joining us also is Nita Beecher. Hi, Nita.
Hey, David, how are you today?
I'm great. And you?
I am peachy keen. I'm just happy to be with you guys and talking on a very interesting subject.
Well, I am too. And Nita has just a ton of experience in helping employers comply. So let's just jump right in. I don't want to waste a minute and make good use of all of our listeners' time. So Sarah, just a word about who we are. I think most of you attending are familiar with us, but we're based in DC. We do focus on the federal agencies and counseling and advising employers on compliance, including among many, the EEOC, particular relevance today. And many of our attorneys have very extensive experience, either with agencies and corporate settings, et cetera. So we've been at this for a while and do a lot of this. This is really what we do. I would also call out, in addition to our webinar, we have a pretty good resource page that we've stood up on the website. It is a real treasure trove of information. We get a lot of good feedback on that. We post the executive orders and all the key developments that are occurring in real time, usually within an hour or two after the event. And we also regularly do a podcast where we unpack those. And again, all that information, you can go right to the website and get that, and I would encourage you to do so. Well, let's turn to what we need to cover today, which is the EEOC. In this tumultuous time, I think many folks are so preoccupied with the NLRB or the Labor Department or 11246, sort of like, oh yeah, and the EEOC. Well, oh yeah, the EEOC, there's a lot going on. There have been a lot of changes, not only in staffing, but in some of the policy initiatives. So we want to start with unpacking a little bit of the in with the new, out with the old. I think that pretty well captures it. We want to contextualize a little bit about these independent agencies that are under fire by the new administration. Of course, one of the key news items is that there is no longer a quorum at the EEOC. Leslie's going to help us understand what that means and what can occur and what can't occur. EEOC's issued some very specific, interesting responses. The acting chair has on defending women under the president's new executive order, addressing those. And then, of course, we want to really talk about the priorities for the agency moving forward. We'll be lucky to cover all that in an hour, but we're gonna try and get through all of that and do so in a very user-friendly, employer-friendly way. So let's just jump right in with the new, out with the old. Leslie, do you want to kick that off for us?
Or David. Now, some of you may recall, if we go back 4 years at the start of the first Trump administration, that there was a 5-day gap right after Inauguration Day, where there was no one in charge of the EEOC, and we were all kind of waiting, and then President Trump appointed Victoria Lipnick to be the acting chair of the EEOC. And from the outset, it felt like that EEOC was not going to be a very big priority of that administration. In contrast, at least in my view, in the new administration, it's been clear since day one that EEOC is very much on President Trump's radar screen. So next slide. So what happened on day one? Well, President Trump acted immediately on Inauguration Day, designating EEOC Commissioner Andrea Lucas to the position of EEOC acting chair. So the president took this action pursuant to Title VII. Under Title VII, Congress confirms 5 sitting commissioners of the EEOC, and the president has the ability to designate one as chair and one as vice chair. It doesn't take any type of action from Congress. President Trump had previously nominated Andrea Lucas as the 3rd Republican commissioner, first 2 being chair and vice chair in the prior administration of his first term. And at the end of the Biden administration, Andrea Lucas was serving as the sole Republican on the commission. And that was going on since Keith Sonderling had left the commission last August. Now, for those of you who are unfamiliar with Andrea, prior to joining the EEOC, she was a management attorney, and she has, a lot of advice, a lot of experience advising employers and boards of directors on all sorts of employment issues, including employment discrimination issues. And since arriving at the commission, Commissioner Lucas, who's now acting chair Lucas, and I may slip up on that once or twice, she's done an absolutely terrific job of communicating her views about existing and emerging issues in employment and civil rights laws to the public. She's authored articles, she issues dissents, she's tweeted her views, her opinions, and honestly, I would say she's fairly prescient in what she says. I am always paying attention to what she says because often you hear about this from, others, outside the EEOC. And true to that, in a press release announcing Andrea Lucas as acting chair, she went ahead and she listed her priorities, which mirrored the executive order that President Trump issued that very day and the orders he would issue in the days ahead. And we're going to get into those a little bit later. Now, I wanted to point out that President Trump could have appointed Andrea Lucas as EEOC chair on that day. He had the ability to do that. He did that with the NLRB. And the fact that he did not suggest that either Andrea is trying out for that role or the administration is planning to eventually appoint somebody else as the permanent chair. And second, I wanted to point out that, commissioners have a 5-year rotating term, and Andrea's actual term is going to expire this summer. So this puts her in a bit of a precarious position of both leading the agency, carrying the torch for President Trump enforcement and administrative priorities, potentially trying out for the role as permanent chair, and at the same time trying to get renominated and reconfirmed by the Senate to the EEOC. And this is all during a fairly short and tumultuous period of time. Okay, moving on. All right, so as our first slide indicated, it has been a tumultuous time for the EEOC because what happened soon thereafter? Well, first of all, Title VII says that the commission should be made up of 5 commissioners, no more than 3 of one party. And I wanted to add that another thing that I did before I was at the EEOC is I was actually responsible for the EEOC on the Senate Help Committee, and I was responsible for nominations of commissioners for a while as well. And in the past, it was customary when the change of administrations happened for the chair of the outgoing administration to step down to allow the president to have a majority at the commission. But things have not worked as smoothly under the last 2 administrations for a variety of reasons. So for, say, the last 8 years. And the past 2 EEOC chairs have not had that majority for like most of their 4-year period as chair of the commission. And this time, however, President Trump took the unprecedented step on January 28, 2025, of not only firing President Biden's former EEOC chair, Charlotte Burrows, but also firing the former vice chair, Jocelyn Samuels. And both of these EEOC commissioners had several years left on their term. By firing the two commissioners, President Trump left the EEOC with just two sitting commissioners, Acting Chair Lucas and Commissioner Kalpana-Kodagal, who's a Democratic appointee, which is not a quorum, and we're going to talk about that a little bit. And I also wanted to mention a second thing that happened. On that same day, President Trump took an action which was not unexpected. He terminated EEOC's General Counsel, Carla Gilbride. And this is not unprecedented because President Biden had actually fired President Trump's General Counsel when he took office. But this had nothing to do with, the work. I mean, that Carla Gilbride was doing a bad job. She just wasn't doing the job that President Trump pictures for himself. And he went ahead and he appointed Andrew Rogers, who had served as the chief's counsel to Andrea Lucas as the acting GC. On the same day that President Trump fired all these folks, he also fired NLRB member Gwen Wilcox. And the question on everyone's mind is, do the statutes that created the NLRB and the EEOC only allow the president to terminate commissioners, members of the NLRB, EEOC commissioners for cause, or do they serve at the pleasure of the president? Hadn't been an issue before, but now it is. David?
Yeah, I think there are a couple things that are noteworthy here. I think that one, obviously, we'll unpack this in a moment, but this is part of a broader effort. As they say, this is really a political assessment. This isn't specifically to the EEOC. It has a broader context involving, and Leslie referenced the NLRB, which has received a lot of attention and removal from many, many other agencies. Including commissions, and that's really become kind of a touch point on this. The other thing I just want to touch on is that Andrew Rogers, who has been named to backfill for Carla as the acting general counsel, Andrew formerly was the counsel to now acting chair, but then Commissioner Lucas. So that I think is, from the, at least how those two are going to work together during this period of time, significant. The White House didn't just drop some political appointee in that didn't know this is selected to be supportive of the chair, the acting chair, and I think will be very helpful to her.
One thing that we've talked about, David and Leslie, is the fact that under Title VII, as I recall, there is no for-cause requirement, which I believe the board does. And Leslie, you've explained to us, and we'll talk a little bit more later about EEOC's quasi-independent status, and David's going to fill us in on that. But it would seem to me that while I think we're pretty sure Charlotte Burroughs has found an attorney and is probably planning on suing, we haven't heard anything about Jocelyn yet as to whether she's going to sue. But I think it's makes it more difficult for them because there's not a stated for-cause standard. Don't you think?
I mean, absolutely that it doesn't say anything, but it was always, presupposed. I had always heard that the Title VII was fashioned after the National Labor Relations Act, but obviously that clause is not in Title VII, the same clause that is in the National Labor Relations Act. And the fact is that the language appointing the EEOC and is very similar to a 5-year term to the language that appoints the general counsel. So in some ways, when President Biden fired the general counsel, it opened the door to this challenge, but that's not to say it wouldn't have happened anyway.
Correct. So like many things in Washington, when the pendulum swings, it goes back to where it was with the other side and swings even further. And this seems to be the case. Well, let's talk a little more about some of these other kind of the broader context, which are these independent agencies under fire. And this is what I was alluding to a moment ago. And just jump in the next slide. Sure. So there's this longstanding precedent, 90 years old. It's referred to as the Humphrey's estate case. And in that, it said that these multi-member commissions could serve for a term, and that basically Congress could enact provisions. These aren't at-will employees. Like if you think about the cabinet officials, the president's cabinet officers, they serve at the pleasure of the president. We all can recall lots of examples. Different presidents have fired cabinet officers if he or she didn't perform in the manner the president wanted. That is accepted. What happened, and this goes all the way back to FDR, like I say, 90 years ago, so this is the mid-30s, 1930s, as these new agencies are being stood up, we begin to develop what today is very commonplace and widespread, these multi-member commissions that have quasi-independent regulatory power and some adjudicative power. And the question that has been raised, and it's been raised foursquare by President Trump and his administration, but this is not a new issue. It's one that has floated around a bit. The question essentially is whether these agencies violate the president's authority as the unilateral head of the executive branch to be able to control the federal agencies for which he's responsible. And if you sort of pause on that and think about that, the argument, and this is called the unilateral executive, so it isn't just deference to the executive branch, but it's actually the power lodges with the president, the position of the president, that it is the president who is accountable for whether agencies function as they should, who makes the policy decisions on that voters have control by voting for the president or not voting for the president, the policies that go with that. In the case of Mr. Trump, President Trump, his argument is, look, I just won an election. I was given, his words, a mandate. I'm going to be held accountable for fulfilling that, and I have to be able to control all of the executive branch, including these agencies.
You know, David, we've talked about this a little bit on other podcasts and webinars because we saw some of this with ALJs going back to the Jercasey case the Supreme Court took. They left down in the Fifth Circuit and upheld the idea that the SEC's ALJs violated the Constitution, the Appointments Clause. And that, I think, is also part of this unitary executive theory as well, because they had two layers of protection. And here you have NLRB members and others basically having a term.
Having a term, which suggests, since they have a term and they're not at-will employees, these statutes that Congress has created, and as Leslie explained, not so much for EEOC, but for the Labor Board and others, have these cause provisions. You know, you have a term, you can serve for 4 years, 5 years, whatever your term is under the statute, unless there's cause, in which case you can be dismissed.
There are also, member bodies with multiple members, and they are bipartisan. They were set up that way for a reason, not necessarily the reason being that everyone's going to be in lockstep with the president. This is me being an institutionalist, David, but I understand the theory, but for many years we did have a reason and a basis for these multi-member commissions and the way they were set up.
Absolutely. And that theory, this is something that all of us in our working lives have been very comfortable with and assumed that these agencies were, if you will, legitimate. So it's a question that has pretty fundamental, ramifications. It's much broader than EEOC or the NLRB. It goes to the Securities and Exchange Commission, the FTC, the FCC. There's a whole alpha soup of these independent regulatory agencies. But moreover, in addition to challenging these agencies, and there's been some litigation, both member Quinn Wilcox from the NLRB is pursuing a claim. Hers will probably be one that lands rather nicely. There's also the head of the special counsel who has succeeded in getting a short-term, what's called a temporary restraining order in place. The Supreme Court declined to review that case more on procedural grounds. But even that, with Justice Gorsuch and Alito, I believe, both filing a dissent saying, no, we would review it now. I have no doubt how they're going to rule. They're going to recognize this. They've been outspoken on this point in prior decisions. Additionally, and we're up to 75, 76 executive orders at this point, unless one's come out earlier this morning that I missed. But there is a specific executive order where, consistent with the president taking greater control of all agencies, including these independent regulatory agencies, the new executive order says that OMB is now going to be involved in reviewing the policies, the decisions they make, the regulations they issue, the whole enchilada. So this concept that Leslie rightfully says, hey, this is commonplace, we're used to it, whether it's EEOC making its independent judgments, the Labor Board, and all these other agencies, the answer going forward, if the Trump administration view prevails, is no. All of that will be decided, the priorities and the budget, by the president.
I think the most interesting thing to me, and I'd like your all's opinion, is while unclear whether I think EEOC probably was already covered because of its quasi-independent status, and the OMB already does review its regulations and to some extent, I think, his budgets and so forth. The most interesting part of what is now Executive Order 14215, that no one is to have a legal opinion outside of the president and the attorney general, no matter what. And that to me is a pretty amazing position.
Right.
Well, that certainly would vitiate the point of even having a commission, because they're supposed to be policy makers. And if you're not allowed to have an opinion outside of the OMB, it's just very challenging, I imagine.
There were some earlier decisions, and we'll get off this point, where you had commissions or agencies that had a single head involving the Consumer Financial Protection Bureau and the Federal Housing Finance Agency, where the Supreme Court a couple years ago did recognize that the president, even though there were protections there, that under this theory, the president did have the right to remove those single heads of the agency. And indeed, prior presidents have in fact exercised that authority. President Biden fired the head of the housing agency and backfilled, as well as the Social Security Administration. So the issue is new because now we're dealing with these multi-member commissions and agencies where they have multiple members for fixed terms. And my little crystal ball says that when the Supreme Court gets its hands on this issue, and it's not a question of whether, it's just when, that they are going to hold that the president does have broad power, and that these constitutional structures creating these agencies, the congressional structures, I should say, are unconstitutional. So
I just wanted
Leslie.
to clarify one thing, because I don't know if we talked about it exactly, but EEOC is considered a quasi-independent agency. It started off as an independent agency, but then it acquired two of the laws it enforced, the ADEA and the Equal Pay Act, from the Department of Labor. And in doing so, it became quasi-independent. And I was sort of trying to trace what happened over time with some of my former colleagues and some present colleagues on the commission. But over the years, EEOC has given up more of its autonomy, such that, a lot of the things it does are approved by OMB before it moves forward. One of the things that it, does do on its own still is it pursues litigation. So it is quasi-independent, going towards very close to executive branch. Yes.
Yeah, I think that's a great point, Leslie, and I agree with that. And that's helpful because there is this spectrum. Congress has created all these different arrangements. You have this mishmash of EEOC because it did pick up these statutes that Congress had given to the executive branch to enforce that were then transferred down to EEOC. So yeah, but at the end of the day, I don't think there's going to be much ambiguity when we get done with these litigations and challenges, but we'll see. We'll see. But in the meantime, so EEOC is just racked up as part among many, but Leslie's correct. It really de facto is largely a part of the executive branch already. All right, well, let's move on. So
Okay,
what
so
about the
let's,
lack of quorum, Leslie? Yeah, this one's for you.
yeah. So it was uh, interesting because President Trump fired the two of the three commissioners, and that resulted in EEOC operating without a lack of a quorum, which is something that in most instances you would really want to avoid because it suggests, what can the commission do? Because Title VII says you have to have three commissioners to have a quorum and to operate. But thankfully, the commission had actually prepared for that possibility. On December 31st, they had voted to approve a delegation of authority for some of the key decision making that hadn't previously, because it already does, by its nature, delegate some of its authorities to other parts of the commission, so that the commission could operate without three commissioners. And at the same time, EEOC issued an incredibly helpful document. I think it's called the State of EEOC FAQs. And that document explains that the commission is open for business, and it talks about what EEOC can and cannot do at this time. It talks about some of the changes it made, so like it can enter into contracts and things like that. And for the most part, and I'll talk a little bit more about that when we get to the next slide, that EEOC is open for business and doing what it normally does to carry out its responsibilities. But one of the key differences in how EEOC is currently operating without a quorum that is most likely to impact employers has to do with things that occur during litigation. First, while it's true, EEOC can continue to litigate cases, and it does even have the ability to file new litigation, its litigation authority without a quorum is limited to really kind of standard cases. It can approve new systemic litigation, litigation involving major expenditures of resources, cases presenting issues in which the commission has taken a position or proposes to take a position contrary to the precedent in the circuit where the case will be filed, and cases likely to generate a public controversy. So there won't be a situation where the EEOC's acting general counsel is going to come out swinging in terms of litigation on behalf of the commission that is going to, change commission positions. Second, the commission won't be weighing in on any of employers' appellate cases by filing amicus briefs. That's not going to happen. And third, and this is slightly wonky, but it's still important, some of the statutes, such as Title VII, do give employers a chance to sort of a bite of the apple if EEOC issues a subpoena. And to challenge the subpoena, that goes right up to the commission, but not right now. It doesn't. It goes to the part of the commission, the Office of Field Programs, that is in charge of the field, and then because EEOC has delegated its authority to decide those subpoena actions to that department. So it basically does not give employers as much of a shot to change things on a subpoena enforcement action. And now I wanted to talk, let's go to the next slide, about what EEOC is doing, and then move a little bit more to some other things they can't do. They're still accepting charges. They're issuing rights of notice to sue. They're investigating. They're conciliating. They're mediating investigations. Although I do understand there's been some slowdowns on the commission's part in operations in recent days. I have heard anecdotal stories from employers that have seen commission just slow down on some things. And if we were paying attention just right before the change in administrations, EEOC actually issued its annual, statistics, and it is back up to close to 90,000 charges of discrimination having been filed. And that was not uncommon when I was at the commission, but it's gone down in recent years for a variety of reasons. So those are back up. So, it's always harder for the commission to operate when it has more charges because a big part of its job is to investigate those charges. So lack of a quorum, and the commission already has less employees than it's had in quite a few years. Okay, so here are some things that also we should keep in mind. For the most part, the lack of a quorum has the biggest impact on the commission's policy making abilities. And given what you just said, David, maybe that is part of what President Trump intended. And that means it can't issue new regulations or guidance, but it also that it can't undo anything that it voted to do previously. So it can't modify or rescind existing regulations or existing guidance. Now, I want to make a distinction here because there's a lot of things at the commission that are called guidance, but they're not the guidance that the commission necessarily votes on. And I'm referring to things like technical assistance guidance, Q&As, and other regulatory sort of assistance that the commission issues. Those are exclusively within the chair's purview. And he or she is not supposed to be going beyond what the commission positions are on those, but it's their decision to issue it and it's their decision to take it down. So if you've been on the commission's website and you've seen things that maybe you found helpful in the past and they're gone, they were probably technical assistance guidance and they were probably issued under a past administration. One of the areas where I don't think this lack of a quorum makes a practical difference is on the commission's priorities. Now, we've heard a lot talked in the past about the commission's strategic plan, and in recent years, the commission's strategic enforcement plan. That is that kind of detailed document where it goes into every single issue area that the commission is supposed to prioritize. This was a creation of the commission after I left, and I found it enormously helpful as someone who works with employers and knowing what the commission is moving forward with and prioritizing. But and they do vote on it, but the bottom line is the way the commission is structured, at the end of the day, the commission priorities really come from the chair. And we're seeing that in real time now because the current SEP is still there, but we're starting to see the commission emphasize different issues. And it's also to a point within the, the litigation priorities, what they're going to send up to the commission comes from the general counsel. So again, I think as we watch the commission, we should be aware that, the chair has a lot of influence. All right. So moving on.
I think, Leslie, before you jump into it, I was really surprised when you shared with me about the delegation of authority from December. I just think that's so interesting that occurred. Obviously, there must have been some inkling that none of us had that something might happen or that people might be leaving for a variety of reasons. So it was interesting. And I think it does speak well to the then commissioners as a group for kind of a good governance approach, because the contrast, the NLRB is effectively dead in the water at this point. There's very little that agency other than ministerial tasks can do. Whereas EEOC, and I think you've laid out very nicely, very much open for business, and there's a number of things that are occurring just as before, which is interesting.
Well, some of the things that, EEOC has always delegated some of its litigation authority down. Too much of it when I was there, and I'm glad that it gave commissioners their vote back. But some of the things that the commission did, I mean, voting on contracts so it can keep running if there needs to be, you know, tiny changes to regulations, things like that. These are small changes, but they make the commission functional. I don't think any of the things that I named make the commission stop, which is important because it has a very important role. I mean, people cannot adjudicate their rights in court without going to the EEOC, and without a quorum, the EEOC does not operate. So, you know, thank goodness for that. Again, I'm showing my signs as an institutionalist, but, you know.
Well, as we go to the next slide, I think the other important thing to remember, you know, you were talking, and we'll talk about the acting chair here in a minute as well, is that this was a unanimous vote by the commissioners that were on the commission at the time in December. So there was no split between the Democrats and the Republicans. I think I think she is as much as an institutionalist as you are, because you served as a Republican vice chair when you were there. And I think that's important to remember. And I suspect that her interest is in doing what is necessary under the Trump administration, but also to protect the organization as much as she can. So with that in mind, so one of the first things that Andrea Lucas did as acting chair was to take President Trump's Executive Order 14168, also known as Defending Women from Gender Ideology Extremism and Restoring Biological Truth to the Federal Government, aka Defending Women, because that's too long to remember. She took that to heart and basically issued a very detailed statement at the time. And as Leslie has already talked about, there's some things she can't do, and we'll talk about the harassment guidance as well as the PWFA in a minute. She can't revise the harassment document, but she did do a lot of things. They had an agency pronoun app. They removed X gender markers from intake forms and MX from charge forms. And I think most importantly, Leslie, you talked about this. They removed just about anything that could be interpreted conservatively as promoting what the Trump administration would call gender ideology from both internal and external websites, including information on the Supreme Court's decision in Bostock, which found that Title VII covers gender identity and sexual orientation. Let's go to the next slide. I think that one of the things, Leslie, that you were going to talk about is what the acting chair decided to do about pending transgender charges.
Yes. So the issue that came out is that the EEOC's investigation of charges filed by transgender workers in pursuit of litigation on behalf, it's not simply about the EEOC guidance, which is sort of how it was poised, but rather I think it's about, as you said, the 2020 decision in Bostock and Clayton, because in that case, the court decided, as you said, that Title VII covers transgender workers. But going back to this issue, what happened is that the EEOC chair said, hey, all the charges that are raised, that raise this issue by transgender employees need to come up to me, and they're just kind of sitting there. And while they're sitting there, the only thing that we know for sure is that if a charging party requests a right to notice to sue, that they can have a notice to sue, which of course they're statutorily required to do. If I'm an employer, I wouldn't be concerned in the short term, or really for quite a while, if I was defending against one of these charges, that EEOC is going to put any resources into investigating or litigating it. And then there's the second point, which is that what the agency did on, I believe it was February 14th or 18th. It all's just been happening in quick progression, but it started withdrawing from litigation that had been filed on behalf of transgender workers. And again, this was a little bit unprecedented because we've never seen a situation where the EEOC pulled back on a case it was litigating for reasons that had nothing to do with, issues with that case. Or in this case, what the EEOC said again to the plaintiffs that, that it was litigating on behalf of the employees, look, you can get your own attorney and continue to pursue it, but we will not move forward and litigate these cases because we believe that there's a conflict with the executive order. And again, completely unprecedented. And that, go ahead.
It's interesting, Leslie, just quickly before we let you move on and talk about the Bostock decision itself. But if you think about it, this new executive order that David was mentioning really kind of ties into this, that all of the agencies are going to be aligned with whatever the administration's policies and practices are. And so in a sense, the agency doesn't have a lot of choice if they're going to follow the requirements of this administration.
Well, remember before when I was saying the one independent area of the EEOC that I felt like was still remaining was this litigation? Well, here's a prime example, and that's why we're seeing something that is absolutely unprecedented. So but there's another reason it's unprecedented as well, and that goes to the the heart of Bostock, because that very decision says that transgender employees are when you discriminate against them, you are violating Title VII. It's exactly what Title VII forbids. I think that this, quote from the Supreme Court on the slide says it. And that decision came out just 4 years ago and was authored by Justice Gorsuch. So if the firing of an individual for being transgender is sex discrimination, and if that's prohibited against, under Title VII, that's a consideration. But you know what? It's really not the first decision of its kind. I mean, it's the first that went exactly that way. I mean, we can go back to the Price Waterhouse decision, which said terminating an employee for not conforming to their gender is sex discrimination. Or, slightly more recently, the Colley decision, where the court held that same-sex harassment, where one male coworker harassed another male coworker who was, not masculine enough, is sex discrimination under Title VII. So it's really difficult to understand how the Trump administration is going to square this line of cases, most especially the Bostock decision, with an executive order that the U.S. shall enforce laws governing sex-based rights and protections, opportunities to protect men and women as biologically distinct sexes. Now, maybe they can find a way to square that. I don't really know.
Well, and I think you've got another slide that talks about the argument that we've seen is that while there may be a right for transgendered individuals to be protected under the law, they're not allowed. We don't have to have pronouns for them. We don't have to have bathrooms and so forth. We don't have to take that into account. And they cite this particular part of the decision. But Leslie, I think if you add Muldrow, the new Muldrow decision to this, what do you think that means in the longer term?
Well, I really think that, it puts this whole line of reasoning into a bit of a box. I mean, because again, Muldrow says terms and conditions of employment, if you discriminate based on those, that's also a violation of Title VII. So while I've heard some folks say that, maybe they will limit Bostock to just terminations, or then that would leave out harassment, but it would also leave out terms and conditions of employment. And I don't know exactly how we are going to deal with all these issues moving forward. But I do know we have executive orders that talk about bathrooms being separate, that women need to have separate bathrooms. So that is essentially the way this administration views the law of the land, regardless of what the Supreme Court says. But it's very clear that the Supreme Court said it was not ruling on that.
Right. Well, I think it's inevitable. The court's going to get the last word on this. And to
Absolutely.
sustain the Trump administration's position, it will have to not necessarily cut back on Bostock. It'd have to cut back on how EEOC has interpreted Bostock. But I think Nita's point that Muldrow would have to be significantly pared back in order to provide such a narrow reading to Bostock. I mean, Bostock doesn't live by itself anymore. It has this subsequent decision for all terms and conditions per Muldrow, and so I think it's a big deal, and I think that the court will make the call.
Yes, but I don't see the court moving backwards on Muldrow, because I think that a lot of folks will see that as a way to get to the DEI issues that they don't like, because those are terms and conditions of employment. So
It is kind of a double-edged sword, yes.
Yeah, yeah.
I agree.
Well, we do have some litigation going on. A little would be an understatement. So if we go to the next slide, let's just, we're starting to get a little bit closer to the end here. And so there are multitudinous, let me see, I counted, there's federal court cases on the harassment guidance in Illinois, Alabama, California, and New York. And the interesting thing that Leslie, you clarified for us is that when the DOJ, when DOJ represents EEOC versus EEOC represent itself, in cases where EEOC is sued, as it was both for harassment guidance and PWFA regulations, DOJ represents EEOC, as opposed to when EEOC itself is suing a company. And go ahead, Leslie.
Except for when it gets to the Supreme Court, and then it's always been represented by
right.
DOJ. Just to clarify, but yeah.
Well, and I recall, and I swear I cannot remember which case this was, in one of the administrations, and it might have been the first Trump, and it might have been Bostock, EEOC filed its own brief in the Supreme Court against DOJ. And I remember that did not go down well in that first administration, as I recall.
Well, I don't think we're going to see that in this administration, if how David described. And it's not the first time. We have had situations where two agencies have been in court against each other. And I heard from attorney friends saying, what is going on? Why is my agency suing your agency? I think we know one thing, it's that we're not going to see that kind of shenanigans in this administration.
Well, it's important to point out. So DOJ has made it clear it wants to try to withdraw itself from the harassment cases, the PWFA regulations and the harassment guidance. The question there has to do with the expansion of Bostock, which people feel, as far as that is the biggest criticisms, that it's harassment to misgender someone or not to allow them to use the bathroom of their declared sex, gender. PWFA, the biggest problem there really is the abortion, that abortion, having or not having an abortion, if you need an accommodation, has been the big issue. So what's interesting is, if you read, and on the day that the Eighth Circuit issued the decision allowing the Republican attorney generals saying they have standing to sue over the PWFA regulations, sending it back to the district court. Acting Chair Lucas reissued her concerns that she raised, her dissent actually, to the PWFA regulations. So what do we think this is going to look like when she has one more person on her side? Well, she is going to probably eliminate in the PWFA regulations things that don't apply to either childbirth or pregnancy. She felt that they had gone way too far. The litigation has actually only been over abortion. It has not actually been over the other aspects at this point. On the harassment guidance, again, that was really focused more on an expansion of Bostock, which either will or won't happen. But anyway, so that's where we are on the litigation. And David and Leslie, I think we're ready to start talking about what's next.
Great.
Okay.
Leslie, maybe you can kick that part off for us on what your crystal ball tells you we'll see and what the acting chair has indicated.
Well, the beautiful thing about the acting chair is that she is so communicative that I don't need my crystal ball. So let me just say that. All right. So next slide. I think it's important to keep in mind that, like, right from day one, Andrea Lucas, in her press release, she put it right out there, all the issues that she was going to look at. And then, she has sort of an extra bucket there. Rooting out unlawful DEI or illegal DEI. She called it unlawful, by the way. I just want to point that out, which I think is better. DEI motivated by race or sex discrimination. Andrea Lucas has been very communicative on this issue. She had debated Jocelyn Samuels on multiple occasions about it. And I don't mean a really harsh debate, but just like her view on it. And I think we are going to see, cases moving forward in that area. A second area, like religious discrimination. Andrea has always talked about fighting against anti-Semitism, but also there's also anti-Christian discrimination, and these track some executive orders that President Trump issued, not the day she was in the White House, but after that. But these were right in her original statement. So again, protecting workers from religious bias. Now this third area, this area of anti-American bias, I'd say this was also an original statement, and it's not something we haven't heard before. I do recall some stuff coming out of Department of Justice during the first Trump administration in this issue area, but I can tell you that on February 19th, Andrea issued, she vowed to protect American workers from anti-American bias. And in the press release, she said to employers, if you're part of the pipeline contributing to our immigration crisis or abusing our legal immigration system by preferring illegal immigrants over American workers or even legal immigrants, you have to stop because the law applies to you. And right around that time, there was an announcement of a $1.4 million settlement that EEOC came to with a hotel in Guam over allegations that hotel had provided non-Japanese employees, including former employees of American national origin. So they had preferred the non-Japanese employees over the other employees, including American, and that was in wages and benefits and terms and conditions of employment. There's that pesky term again. And again, that resulted in that settlement. And I definitely think we are going to see that in the future. Nita, do you want to talk about some of the other things that we're
Sure.
going to see?
I think, well, one thing I wanted to mention, Leslie, you mentioned the executive order that you were talking about, the anti-Christian executive order, 14202. Andrea will be on a task force along with a whole group of other people, including the AGs and others, that are going to review agency action to identify unlawful anti-Christian policies and practices and recommend actions. So that's yet another thing that, and it's right, I think, something that is very much close to her heart. Okay, so we talked about harassment guidance and PWFA. I don't think we need to beat that to a dead horse. Yes, Leslie.
I mean, and then we were going to talk about, I think it's just important to talk about where they're deprioritizing as well. And we talk about disparate impact. This, you know, this is statutory. It's part of Title VII. UGASP is not statutory for EEOC. It's a guideline. And I think this goes hand in hand with this administration's deprioritizing any kind of administrative action that would limit AI. And so go ahead.
And well, I'm gonna let you finish the AI one because I want to talk about the EEO one.
Oh, okay. I'm sorry. I jumped ahead of you. I was just
okay.
thinking about that. Yeah. So one of the things that was removed from the EEOC website was an excellent guidance on AI and how it affects disabled workers. So and that's unfortunate because I thought it was really helpful for employers. But in any event, I think that, you know, it's just not a priority for this commission, for this administration or this commission.
Well, the deprioritizing of the disparate impact and the future of the EEO1 report, I think, are also tied to Project 2025, which does recommend the elimination of both of those. Obviously, disparate impact in and of itself can't be eliminated simply by the agency, but deprioritizing cases that involve disparate impact could be done. And David, as we've discussed, I think the EEO1 report is actually a Reduction Act. The actual statute itself does not say what kind of data will be collected and actually doesn't mention race or sex or ethnicity, which is in the EEO1 report.
That's correct. And so at the end of the day, Title VII authorizes the commission to collect workforce data. Within that authorization, the EEO1 clearly falls within the authorization, but many view it as that whether there's a quote mandate, a congressional mandate. I think that's a slight overreading of the statute. And I think with the rather aggressive OMB efforts that are obviously well underway, it's easy to imagine review of the Paperwork Reduction Act authorization, and particularly the cost benefit analysis, looking at the burden versus the costs, et cetera. And I think that either driven by OMB or perhaps when there's a quorum with the Republican majority in place, these requirements could be, there's clearly a strong interest in doing away with EEO1. So I think at this point, it's really a question of when, not whether that's going to occur. When and how. Those answers we don't know, but I think EEO1 shelf life is pretty short at this point.
Well, guys, we only have a few minutes, so I can't believe it, but moving to final thoughts.
Yeah, final thought. I'll do the first one, just let our subject matter experts roll with this further. We have focused appropriately on the federal standards, but the state law, I mean, whether this rollback of, biological sex and gender or all these other issues, expansive definition of pregnancy, what is or isn't protected, and the abortion issue, whatever happens on the federal front, do not forget these state law requirements. And I can envision a day in the not so distant future where employers may be whipsawed a little bit between differing and potentially conflicting requirements, which has not typically been the case, and how to reconcile that. The abortion issue has given us some experience on how to bridge those dynamics, but I can see it being much more widespread. So that's one that I think is going to be one of the most interesting developments, is how the states continue to pursue, and there's every indication that they will.
Leslie?
Well, I mean, I think that those that think that maybe the EEOC is going away, and I don't think there's a lot of them. It's not going away. It is definitely in for the ride of probably the biggest change that it has had in years, maybe since it got litigation authority. Honestly, it's huge, and um we will have to just watch it very closely to see, what happens next. I think the employees there are under incredible pressure these days, as are many federal government employees, and they are really trying to do their job. There is one issue area that I wanted to mention that I did notice, that Andrea Lucas also mentioned, that we may see some more activity on EEOC's part, and that is that they can investigate state and local governments, and she has talked about that includes public universities. So we may see some EEOC investigations under their authority. Then they turn the investigation over to justice. So we'll have to see what happens there.
Great tip.
Wanted to mention that.
All right, Nita.
With all that, I would just say that EEOC has always been the premier enforcement agency, as far as we're concerned, in anti-discrimination, and I think that's going to continue in what other form moving forward.
I agree. Well, listen, I want to thank Leslie and Nita, both of you, for terrific discussion on really super timely issues. I mean, we're down to what's happened in the last 24 to 48 hours. That's wonderful. Just give a quick shout out. We do, I mentioned this before, our resource page. You can go to our website, www.FortneyScott.com. All these materials are there and more, and we upload this once to twice a day at the cadence we're running now. So it's pretty well kept up to date. So with that, Sarah, I'll turn it back to you.
Great. We'd like to thank you all for joining us today. If you have any further questions, please email us at info@FortneyScott.com. A recording of this webinar and a copy of the PowerPoint will be available to all those who attended. This will be sent as soon as the webinar recording is available. Stay tuned for our next podcast and webinar.